the children playing a first-person shooter game, having them pretend all the enemies were NP, my client's paramour.
He's on Adderall, and I would like to know why he's on Adderall. I do not know why he's 9 years old. She's got him on pills. She does not inform me of absolutely nothing. She does not communicate with nothing.
You're on a short leash because you got the eyes of the
That's
court
right.
on this now. You both are acting too much like lawyers. Start acting like people. You're going to end up in front of Judge Gottlieb and probably end up in the Kent County Correctional Facility.
The full amount that he owes me is $194,845.
The plaintiff in this matter, Autumn Bailey. Miss Bailey, good morning to you.
Good morning.
Next on my screen is the defendant, Javon Evans. Mr. Evans, good morning to you.
Good morning.
And on behalf of Mr. Evans, Attorney Jonathan Browning. Mr. Browning, good morning to you.
Good morning.
I read Ms. Lomas's motion. Anything you want to add before we hear from Ms. Bailey?
Yeah, just to clarify, Mr. Evans has had trouble with the opposing party unilaterally changing the parenting time schedule. She gets the child 1 day a week and she tends to unilaterally change it. He is also having some difficulty with her lateness at exchanges interfering with his employment. And he doesn't have our understanding is that opposing party, Miss Bailey, does not have her own residence right now. That said, Mr. Evans is still not asking for her parenting time to be taken away, but we don't have a way of confirming or knowing this. So those are the things that I would add to what you've already received.
Thank you. Ms. Bailey, your thoughts, please.
Yes, Your Honor. I have consistently made desperate efforts to take my son consistently on the days I'm supposed to get him, but Mr. Evans is a very difficult person to co-parent with, and a lot of times it turns very verbally abusive. In the past, he's physically abused. I've had to get PPO on him. He's difficult to deal with. And I've just been trying to just have a set schedule, and he'll like call the day after I have Tyson and he'll do something like, just last week, I was supposed to have him for the whole week. The day after I get him, he calls and asks him if he wants to go paintballing. And then the week before that, we're at his tournament and I only had him for a day. And then he invites his friends over to his house. So Tyson wants to go home. It's a manipulation. It's a game for him. He went live for 20 minutes about me on Facebook. It's impossible because he's so abusive towards me. And no matter how many times I try to be nice and get along, he just won't do it. And I have all the evidence of the abuse.
Okay.
And I can submit it to the courts if you would like, because
I don't need it today. Thank you. Well, Mr. Browning, I'll give you the last word. I'm not a fan of these Facebook things, so to that extent, you can advise your client to knock that off, please.
Well, that would be fine. But then generally, yeah, what my client was seeking was to reaffirm or to reestablish that parenting time in terms of what day the opposing party is supposed to have child. She has changed it unilaterally about 4 times, he says. So right now, he's kind of just dancing to her tune in that regard. I'm sure he would disagree that he's been abusive. And as you see, the file number on this begins with 10. So these two have not been living together for like 15 years, we can gather from that. So I don't think that she has a lot of contact with him. I mean, I could be wrong if this was filed originally as a child support case or if they reunited later. But when I see a case number beginning with 10, I think that it's been since 2010 that they've been having this disagreement. The child is also about 16, I think, which would suit a case this old. So, the child wanting to go over to his dad's because of friends and stuff is fairly normal, and a certain amount of autonomy would be normal too.
Well, I agree with you. If the other parent doesn't simply um, do things that would make parenting time difficult for the other parent because the child's going to want to be at their house, like inviting all their friends over, playing paintball, doing all these things. Um, what does the order say what day it is?
The order had said Friday.
All right. So if they can't agree, you default to Friday. Very simple.
Okay.
There's no other way to. I hope parties um, can agree, and I agree with you, Mr. Browning, that um, there's been, at least from my perspective, very little by way of involvement with the court in that. Um, there's some allegations in here that are kind of troubling, and um, so I can either just tell you you default to Friday and then be done with it, um, or do you believe that enough proper cause or change of circumstances per shade has been alleged to proceed with a investigation and recommendation?
Well, Your Honor, my client is concerned about opposing parties' living situation. Since she got out of incarceration, she's bounced from place to place. None of these have been her own residence, to our knowledge. Beyond that, it's been at least 5 years, or possibly 7, since the last time that child support and parenting time were reevaluated. So this
All
case
right.
is eligible for that.
Well, and I just want to point out the fact that I understand that when you have a sheet, so to speak, it becomes a little bit more difficult um, to secure places.
Yeah.
But I think what I'm going to do is this. I'm not going to make any changes today, but just reiterate that the parties, if you follow the old order until it's changed. But I do believe, pursuant to Shade versus Wright, 291 Michigan Appeal 17, a 2010 case, that the more expansive definition of proper cause or change of circumstance has at least been alleged, and I do find probable cause. Um, the obviously poor communication and lack of cooperation between parents is always a change of circumstance, revisit parenting time, because as stated in MCL 722.23J, it diminishes each parent's ability to encourage a close and continuing relationship. There's other issues too. Obviously, there are mental health issues, drug issues, non-payment of support, got issues such as stability of residence, which puts into question MCL 722.23 D as in David. So I'm not going to make any changes today, but I'm going to grant your motion in part, Mr. Browning, and I'm going to refer the matter to the Kent County Friend of the Court's office for a complete investigation and recommendation into the issues of parenting time and child support. And the fees for that will be paid by your client. So I can assure that this case will not be administratively lost and we have to start over. So, but you can prepare an order also that says the current schedule, unless the parties agree in writing, will be followed pending the investigation. Okay.
Okay, one last thing then. I just want to confirm with the parties that their understanding is that the original date way back when was Friday, last that it was put in place by the court. Is that your understanding, Autumn and Jovan?
Yeah, actually, I've been trying to get him on Fridays, and Javon has been giving me a hard time about that. So I tried to get him the last day of school, and he told me no. I have the
I-
text messages for that too.
Okay, but Friday at like 4, 5, 3. What do you guys
Whatever
think?
the order says.
All right,
And also,
Friday.
Mr. Browning, I'm not going to order it at this point, but I would like you to discuss with your client and the possibility of using our family wizard. Maybe that would help with the communication issues going on between the parties. This thing hasn't been looked at since 2018, and uh, we'll uh, we'll see what we can come up with there. So I'll do the order of reference today. All right.
Excuse me, Your Honor. Can I say something, please?
No, the only reason that is this, Mr. Evans, is when you're represented by an attorney, your attorney does not want you talking to me directly because even though it may be something very innocent, it could affect your case. So
Got you. Got you. Okay.
what you should do is ask or talk to Mr. Browning, and if he thinks it's something that needs my attention, he'll bring that to me. But I'd love to talk to you all day, but your attorney would slap me right through this screen if I started talking to you. Okay?
Okay, Your Honor.
All right, you're
I
all
wouldn't
set.
dare for real, but maybe you, Javon.
All right.
Okay, so when does it go in hand? Because like I said, I don't know the parenting time because she's never followed it.
Well,
So
contact your
So
attorney and he'll tell
okay.
you what the last order is. We're going to follow that unless the parties agree in writing. Okay?
Nah, I don't want no contact. So
So that's how it is. So
okay.
we are adjourned. So this matter was adjourned from our last motion date because there was an issue relative to service. Um, has that issue been resolved, Ms. Nink? Did you get a copy of?
Yes, Your Honor, it has.
Okay, thank you. So I read your motion, Mr. Stokes. Is there anything you would like to add before we hear from Ms. Nink?
Yeah, I would add a couple things that's happened in the since then. My son, for some reason, and I knew about this, but without me having any kind of consent, he's in Florida right now. There's a parenting time order in place. She has not followed that at all, not whatsoever. That's why we're at where we're at right now. But I don't know his whereabouts. She had let me know that he has a phone number that I could contact him with. However, now I'm blocked from that phone. I have no idea why. There was nothing going on, but I cannot call my son. I cannot get a hold of my son. I cannot communicate with my son. This kind of started back in December. It's slowly progressed into now I just can't have contact with my son, according to Miss Nink. So it goes beyond maybe having a parenting time order revised, but I'm kind of looking at like she's in contempt. She hasn't let me see my son. He's in Florida. She said I had to go to Florida back. My brother-in-law broke his hip. I had to go back to Florida and kind of help with him in Punta Gorda. And she said at the time that she was the first person I called to let her know about this. She was fine with it because he was going to be going to Florida to his mother's house and his mother's boyfriend's house. Well, he's there. She dropped him off, went there for 3 days, and now he's supposedly going to be there till August. And she just basically didn't ask me. She told me, and he's there. I can't contact him. I don't even know where he's at, what town, anything.
Okay.
And then it changed. All of a sudden, I couldn't go and see him or pick him up in Florida and spend time with him because we had a big event that we were going to spend the summer, in Florida, and then so I came back so I could file these motions, and my brother-in-law is getting well now, and well, I'm back and I need to take care of this and get this resolved because what she's doing, everything she's doing right now is the definition of alienating him from me and separating us. And now he is a little bit spooked and weird. He's on Adderall, and I would like to know why he's on Adderall. I do not know why he's 9 years old. She's got him on pills. She does not inform me of absolutely nothing. She does not communicate with nothing. And this is a problem. We have a very close relationship we had, and it's slowly to her benefit, disrupting it is in every way she can possibly do this.
Does at least according to my information, the judgment of paternity was entered on the 17th of November of 2016, which
Yes.
granted custody to plaintiff mother.
Yes.
So you don't have um, any type of custody which would require her to get advanced approval for such things as doctors, medication, trips to Florida. What is your current parenting schedule?
We had a parenting time schedule that was in 2016 when he was 5 months old. I had to go and get it in front of Judge Denenfield for that because she wouldn't let me see him. That was in probably November of 2016, but it was still in place. We have not updated it because we always agreed to meet in Nunica at a place called Turks. That was like our drop-off pickup spot, and it wasn't really much of a problem there. And then it slowly just turned into what is in her benefit that I can see my son. And I really, and I'm in the dark with in all this. And she's telling me my son doesn't want to talk to me no more. Well, my daughter wrote a statement, and I wanted to hopefully get in front of the judge after this. I don't want to see a referee.
Well, let me stop you a second.
Okay.
You don't get to make that call. All right.
No, I know.
That's not your call one bit. In fact, I can pretty much guarantee it's going to stay here with me. So if
Okay.
that's a problem, then either you're going to have to get used to it, or you're going to have to file your own motion in front of Judge Gottlieb and convince her that she should hear this and not her referee. That's the first thing. The second thing, what is your current parenting time schedule?
I would see him. The schedule was at that time I was only getting 4 days off a month, and I got him both those days every other weekend.
Is that what the order says?
Yes.
Okay.
Yes, and I met him in Hudsonville. Her in Hudsonville. This is when I lived in Holland. She moved to Grand Rapids. We met in the middle there. Since then, it's changed, but it's still in place.
Okay.
Um,
Let me chit chat with Miss Nate. What's going on?
Hi there. Yeah, like you said, I have full custody. Our original parenting time was we talked to a mediator and we agreed that we would meet in Hudsonville. Like he said, he lived in Holland, I lived in Grand Rapids. It was our halfway spot. It worked well for both of us for a while. I'm not sure what the original agreement said. I think it was a couple days a week and maybe one overnight at that point because he was pretty young. We changed it to work with Jared's schedule. I said he could do every other weekend. He kept switching up his weekends and stuff. We continued to do that for a while and it did okay. Then he lost his apartment out there, lost his job. Now he lives an hour away at his mother's house when he's there. So I agreed I would meet him in Nutica, which is about halfway. We were doing every other weekend for a while. A couple times my son did not want to go. He said he didn't want to be around his dad, that he was a jerk, stuff like that. He wouldn't really tell me what happened. He just said his dad was mean and he didn't want to go there. So I'm not going to force him if he doesn't want to go. Like you said, I have full custody. I will work with Jared if it's in the best interest of my son. He knew about the Florida trip ahead of time. I did tell him he's been in Florida almost this entire year. I have proof of this. He is the one that has not been seeing his son. It is not me. And I even arranged a visit with him right before Noah went to Florida. And he comes home the end of July. Jared is aware of this. He did see him the weekend before he left. And I did get him a phone so he could talk to his dad while he's away. If he isn't talking to him, it's because he doesn't want to. He's 9. He's old enough to make his decisions.
No, he's not. Let me correct you right now.
Okay.
No, it's absolutely not. And to the extent that you have relayed that, that stops now. Okay. 9-year-olds don't drive the bus in my courtroom, period. They are not, absolutely not, going to make decisions about, I don't want to go to my dad, so that's that. Because 9-year-olds don't have the ability to comprehend things. It's like when they say, I'm not going to school. Okay. What you do is you put the kid on the bus. That's what you do. Now, granted, when the kid gets 19 or 16, 17, it becomes a little dicier, but but 9-year-olds do not. They're not old enough to make that decision. And they will not make that decision with me. Okay.
I understand, Your Honor. Can I explain that further? I'm sorry, I didn't
Oh,
mean
you
that.
don't have to. I got the picture. The one picture I do have is that the two things I'm going to do today. One, I want your son's phone unblocked from Mr. Stokes.
It's not blocked.
Okay,
Yes,
then
it is. Yes, it is.
stop, you two. How am I going to figure this out? You say yes, you say no. To the extent it's blocked, it gets unblocked, and Mr. Stokes is allowed reasonable telephone contact with your son. That's number one. The second
Okay.
thing is I can't decide this on a Friday morning. I am going to find, pursuant to Shade versus Wright, 291 Michigan Appeal 17, a 2007 or 2010 case, that poor communication and lack of cooperation between parents, which is clearly going on here, does constitute a change of circumstance to revisit parenting time. I'm going to respectfully deny the motion to change custody. I am going to reopen parenting time, however, because there's been a lot of changes going on. We will, are you working currently, Ms. Nink?
I am, yes.
Mr. Stokes, are you working?
No, I am not, Your Honor. I was laid off from my job. I just came back from Florida. I will be going back to work though.
Okay.
I'm a tune and die maker. I'm fine. My brother-in-law broke his hip. It was a family emergency. She was well aware of it. We had plans for him to come with me this summer to Florida, and then she just all of a sudden
Do you
took it
see
away.
do you see what the problem is, Mr. Stokes?
Yeah.
Let me just stop
I'm
you.
upset. I'm upset is what the problem is.
Well, that's good that might be good, and it might be cathartic, but you have just spent 3 minutes detailing things that I didn't ask. The only thing I asked was, are you working? That's it. Okay. And you indicated you're laid off. All right. So I still think you can get your hands on $150. So I am going to send this to the friend of the court for an investigation and recommendation. The fees for that will be split. And we'll see what they say. And if they come up with a recommendation that the parties can live with, they sign on to it. If there's an objection, be very careful. You can't object because, it just does, you wish you had more. Well, it doesn't work that way. So we'll find out once the friend of the court gets things settled. But I want his phone unblocked, and I want Dad to have reasonable telephone contact. That starts now. And just to the extent anybody was saying that, 9-year-olds are not old enough to make their own decisions, period. I make them, unless the parties want to, but I have to make them then. So you're both all set. I'll do the order of reference today. Make sure the friend of the court has your correct information so they can tell you.
I'm gonna have legal consultation after this, probably represent this matter of a friend doing pro bono. Just to help me out, because this isn't how this is only me having a relationship with my son to her when it's convenient for her.
Yeah, we're trying to unwind that, Mr. Stokes. So you're just going to have to be patient and let us unwind it. And I don't care if you come in here with F. Lee Bailey. I would do the same thing. Okay?
I understand. Yes, I understand, sir.
I try and treat everybody the same, attorney or no attorney. Well, you're all set. The one thing I just want you to work on is, please, when I ask you questions, just answer the question directly and don't go off on these. I know you're upset, but it's important that we stay on focus here, okay?
Yes.
You're
absolutely correct. Okay.
Thank you. We're adjourned.
And we're going to be splitting that. We're going to be splitting this, you said.
150 apiece.
All right. Sounds good.
Ms. Hammonds, good morning.
Good morning.
You filed this motion, and Mr. Hammonds, good morning to you.
Good morning.
Good morning. So when you filed this, Ms. Hammonds, you indicated that Ms. Sargent is representing Mr. Hammonds. That's why I asked.
Yep, when I went to file it at the legal assistants, they said that was a lawyer on his case, so they wrote him down or wrote her down.
All right, I'm sure she's not representing you anymore, is she?
No.
Okay, all right. So I have two motions, which I'll let you know that, Ms. Hammonds, I'm not a fan of that. Okay, so in the future, just include it all in one because we really don't need two motions on this. I'm going to start with this. I've read as much as I can read. The motion, Ms. Hammonds, and I know you're representing yourself, but you can't write me term papers, okay? This is 8 pages of things I can barely even read, all right? You don't have to go into all of these details. And then I get motions to dismiss things. You both are acting too much like lawyers. Start acting like people, okay? Because it's difficult to do this. Motions are followed, and the court rule is MCR 2.119. And what you need to do, Ms. Hammonds, is put these in paragraph form, 1, 2, 3, 4, 5, however, okay? I would type them if I were you. It's not because did you write this in pencil?
No, in
Okay.
pen.
It came off really light. You might be a light writer, so I would type it.
Okay.
Okay, so I want you to do this over again, and I want to address your second motion. So I'm going to adjourn your first motion without date. I want you to put it in the proper format, and then I'll tackle that bear when I tackle it. The second motion is a little bit more interesting to me. And what I'm curious about, and I ask this of all people who aren't represented, you're asking for a Lombardo hearing, right?
Me?
Yes.
If that's what the legal assistant, I don't know what a Lombardo hearing is. I'm just requesting for a schooling change.
Yeah, that's
Person.
what happened is I'm reading your motion card and you have Lombardo hearing written on it.
That was written from the defendant to me, I think.
No?
He put in something about a Lombardo hearing.
Well, it's in your motion card.
Okay.
It's on the green motion card. It says Lombardo hearing. And I just was a little confused. So, and I read your response to all of this, Mr. Hammonds, and another thing you're going to learn real quick from me is the best way to get in my doghouse is to attach a bunch of text messages to motions. That's not acceptable to me because half the time I can't read them and half the time they make no sense. And then you got to try and follow the whole chain of things. So the less text messages, the better. But apparently the parties want to change the schooling of your child. Is that right?
Yes.
Okay. How old is your child?
He's 8.
Okay. I usually don't get these until kids are 13, 14 and ready to go into either high school or things like that. So where does he go to school now?
He goes to Coit Creative Arts Academy. His older brother went there as well, but he's going into middle school at a different school this year.
Okay, so and tell me why you want to change his school.
He started there because we used to live across the street. Both of us have moved away now. Neither of us live close. I have to start work at 7:30 in the morning. They don't start school until 9. So I'm requesting that he come to school where I work, which we had a hearing about this before, and you just said whenever I find a job, then submit the new motion for schooling.
Okay. Mr. Hammonds, what say you?
About the motion of the schooling change, sir.
Yeah, that's the only one I'm hearing today.
Okay. I was trying to stick to what we had previously agreed on, not changing the school until middle school. So Percy, yes, he just went to middle school now, but Kairos has this community there that he's built from the beginning. And like, due to all the changes that we have been through as a family, mentally, emotionally, I always thought it was best to finish where he started with that community that he has going into middle school. I think this is a great chance for him to be an individual. He's always been under his brother's coattail as well, but like this is a opportunity for him to really be his own person. But
Is that where your other son goes, Miss Hammond? To the
He
school?
did until 5th grade. He's going to Blandford Nature Center this year.
Okay, so is that the school you work at?
No.
Okay, all right, okay. So when parties have joint legal and joint physical custody, courts rely on parents to make the decision for their best interest. But sometimes they can't happen. And the parties are embedded in their own position, and agreements aren't possible. So when agreements aren't possible, the case, which is called, it was named after one of the parties in that case, Lombardo. That's why they call it a Lombardo. That case tells me that if the parties cannot agree on where a child should go to school, then the court has to step in and make the decision for them. I don't like doing that because, as you know, I don't know your children, and there's only 2 people in this world that know your children, and that's you 2 better than anybody. But if the parties are in that position where they cannot make that decision, then unfortunately I have to do that in the context of an evidentiary hearing. I can't make any changes in that respect. So the problem that you 2 are going to have is this. By the time you get into court, they would have already started school. I can almost guarantee you. Lombardo here, a request to change schools are usually made in November, December of the year before, because it takes that long to get through these things, because evidentiary hearing has to be set, and I don't know how long it's going to take. The evidentiary hearing, we listen to witnesses, we listen to comparisons of the schools. So I need people that know these schools that can compare them. There's official online resources you can check as how they're rated. And all that needs to be put into a brief and witness lists and exhibit list. It's a extremely complicated thing. And you would not be the first 2 that had difficulty representing themselves in doing this. So although it's not required, I would strongly urge the parties to consider either figuring out another way, like mediation, or getting attorneys, because this is going to be a long, arduous process. And unfortunately, when you have legal and physical custody joint, I can't make any changes in their school until such time as the evidentiary hearing is concluded. So I will have my clerk schedule one. I can almost guarantee you it will not be in time for admission. So if you're hoping for this year, that's going to be very difficult unless the parties figure out another way. Sometimes you can. Sometimes I've had parties go talk to their pastor and say, okay, you make the call, or somebody else in the community, or a mediator. There's a lot of mediation places around. Dispute Resolution Center downtown is a good place to do it. They're relatively cheap. And that might be able to break the logjam. But I'll have my clerk set one up for you, and make sure that the court has your correct addresses. If you have moved, make sure those were changed with the court. And I will listen to whatever you send me, whatever I read, and we'll get that thing started for you. Okay?
All right. Thank you.
What kind of hearing, sir?
It's an evidentiary hearing.
Evidentiary. Okay.
Okay, that's what it takes. But I think a lot of times people are not real happy with it, because I always tell people, remember, I have to consider the best interests of the children or the child, and not necessarily the convenience. Although it sounds like it would be very difficult under the present arrangement, but we'll get things started for all of you. And if you figure out another way, let me know. Because
we didn't even have a conversation first. I just got these papers.
Yeah,
I have talked to him about it before.
No, we haven't talked since we went to court with referee Winford before, but since then there's been no communication about school change. I just received these papers in the mail.
Do you want to go to mediation, Ms. Hammonds?
We can.
Okay, Mr. Hammonds?
Yeah, that's fine.
Okay.
That's
All right,
fine.
then I'll direct the parties, and you can prepare this order, Ms. Hammonds, that the parties proceed to mediation through the Dispute Resolution Center. The reason I'm picking them is because they work on a sliding scale based on income. Some mediators in this town will charge you $400 an hour, but they work on a sliding scale based on your income. It's usually only a couple $100. They may help you. And if they do, then you can make these changes right away. All right?
All right. Thank you.
You bet. You take care, both of you, and nice seeing both of you. I always enjoy meeting you again. Thank you.
Take care.
Let me, if I could start with you, Ms. DeLeon. I read your motion. Did you get a copy of that, Mr. Martinez?
Yes, I did.
Okay. The motion is pretty straightforward. I'll tell you what I know, and then I'll let you two fill in anything I don't. But a judgment of divorce was dated 9/14 of 21, and it awarded the home located in Delwood in Wyoming to plaintiff, and the judgment required that defendant sign what's called a quitclaim deed, and apparently hasn't. Is that about the size of it, Ms. DeLeon?
Yes.
Okay. Mr. Martinez, your response.
I never actually got to go to the Zoom of my divorce because I didn't have a phone at the moment. So I don't know what she wants me to sign.
Okay. So does she have your address, your current address?
Yes, she does.
Okay. You have that address, Ms. DeLeon?
Yes.
Okay. So in the next 10 days, you need to prepare a quitclaim deed, and the Legal Assistance Center may help you, but most attorneys will charge you very little to help you prepare that. And then you send it to Mr. Martinez and he has to sign it. And that's what the judgment says, and that's what you do. So I'm going to order that it be done within 10 days. You prepare the quitclaim deed, send it to Mr. Martinez,
Okay.
and he has to sign it and send it back to you, and then problem solved. Okay,
Okay.
Your
Sounds good.
Honor,
go ahead.
I'm not gonna sign because that house is under my mom's name also.
Well,
I
hang
feel
on
like
a
it's
second.
not.
No,
Okay, go
no.
ahead.
Nope. If she sends you a quitclaim deed, you're going to sign it, or you're going to end up in front of Judge Gottlieb and probably end up in the Kent County Correctional Facility.
Yeah, and I have a question.
No, it's not question and answer time, please. Okay. You two are representing yourself. You might want to chit chat with a lawyer, Mr. Martinez, because you're walking down a very dangerous path. And I don't want you to run into problems with that. So that's what's going to be done. If you don't send it back, then Ms. DeLeon, you file an order to show cause with Judge Gottlieb, and then Mr. Martinez can deal with the possibility of going to jail. Okay?
Thank you.
Judgment is what the judgment is. It says what it says. Doesn't matter. It says sign it, you sign it.
But
End
I never
of
got,
story.
I never got a chance to even talk my case because I didn't have a phone and access. She did it on her own. She got a lawyer. I didn't even fight because my kids were minors at the time. That's
Well,
the
that's
only
the
reason why she
problem.
got awarded the house.
That's the problem, is when people decide to do that, then they're stuck with whatever happened. The judgment was dated in 21. It's a long since expired for you to do anything about that. So you got to comply with what's written in the judgment.
No, I'll find a lawyer, Your Honor.
Okay,
I'll see her in court. So I'll
you're
make it easy
already in
for her.
court. You're already in
No, I
court.
know.
The
Yeah,
next
but
court you're going to be in is in front of Judge Gottlieb, and that might not go as well as this one. So
well,
I
I
hope
mean, I'd
for the
rather
best for you.
thank you. Yeah, I'd rather speak my case because that's not fair.
There is no
So,
case. You have no case.
I
I'm
mean,
just telling you what it is.
she know what she's doing.
The
So
deed says what the judgment says, what the judgment said. You got to abide by it. And if you don't, then courts
I
have
know,
serious
correct. I know,
consequences for that.
and I know Michigan laws too. She's not allowed to do this. So
Mr. Martinez, I wish you the best of luck. You're all set.
yes,
with
sir. Thank you.
Thank
You
you.
have a good one.
You too. Ms. Lang, to
Morning.
review. This is your motion, I believe, Ms. Lang, and I was a little confused about it, but so you want supervised parenting time at Journeys, correct?
We currently are ordered there.
Okay, and nobody wants to pay for it, right?
Correct. And I originally, Judge Gottlieb had authorized, and I do apologize. I didn't list, I just noticed in the email or here from Mr. Dickerson at friend of the court, he does specify it's called the AV grant. So I apologize for being vague, but they had authorized use of those funds, but after X amount of, I believe it's a dollar amount, is exhausted, then you have to bring it back. And Mr. Dickerson, I received this email from Mr. Dickerson that said, Mr. Charbonneau, and he recommended I just bring this back to judge or yourself, of course, for that authorization.
Well, and the reason I say that is this. The reason why and what most of those funds do is they're temporary, just like supervised parenting time should be at an agency. Usually the hope is that after some time with supervised parenting time at the agency, it can move to something like supervised in the community, stuff like that, where you wouldn't need a grant. And that's why these grants don't last forever. They're very specific with that. So you still feel that we have to have supervised parenting time?
And it is, I'm the party that is supervised. I don't think that they should have ever been supervised, but that's a conversation for another day. However, judge had ordered a hair follicle test for me to have that done. I have, and that was last summer, and I did, and I've had a very rough year in terms of my health, and that has led to having to change my housing. And I've been in and out of the hospital several times. So I'm concerned that it's not that I have anything to hide, and that's not why I've done it. However, when I reached out to a couple of attorneys and consulted with them, they said, first thing I need to do is get my health and my housing and get in one stable place. And that way, otherwise, if I submit just a hair follicle, I believe that the narrative and the reason for wanting supervised parenting time will then change to stable housing or, one of these other reasons.
Well, the reasons for supervised parenting time not always, one thing or another thing. Sometimes it can be a few things. Sometimes it can be just one. But I'm just wondering how long, and maybe Mr. Crafey can answer this for me. You understand what her motion is all about, don't you, Mr. Crafey?
I do. I believe so, sir. She's requesting grants for additional supervised parenting time.
Yeah. I take it you don't have a problem with that.
I don't. No, sir, not at all. That was me waving the children out of the house. Thank you.
Oh, okay. But my question is even broader than that. It's okay. So I grant this. Usually it's the grant pays the first big chunk, and then the parties each pay $10 or something like that, 20 or something. My question is how long, in your view, does this need to continue, or should it be just simply open-ended and continued on in the foreseeable future?
Your Honor, we've had supervised parenting time for a little over 2 years now. Ms. Lang has a history of use of methamphetamine, and the drug test, the hair follicle test, was ordered 1 year ago. Judge Gottlieb put an order in to reduce the cost of that for Ms. Lang. In my opinion, if until Ms. Lang proves that she's not using methamphetamines or other drugs with a hair test, then I have to assume that she's still using that. She mentioned a rough year. It has involved more legal troubles and accusations, some crimes that have been committed. I'm definitely open to supervised parenting time in the community. I don't like driving to journeys every week for this supervised thing. It's a pain in the neck, and supervised in the community would be healthier for the children as well. I do think that that some sort of supervised time is required until Miss Lang proves that she is making healthier life choices for herself and for the boys.
Thank you. Well, first of all, addictions are a rough thing. And I wish nobody ever had to go through that. It's very difficult, and sometimes it's 2 steps forward and 3 steps back and 1 step forward and 2 steps back. And it's as long as the person is committed to sobriety, it may take some bumps along the way. I get that. But here's what I'm going to do. I'm going to grant your motion. We'll reapprove the grant for you, so we can get that started. I can't go retroactive until that date. All I can do is go forward from here. But I want you also, I don't know what your level of communication is. If you're able to talk on the phone, if you're able to email, if you're able to text message, whatever, or send letters. I would like.
We use our family.
Pardon?
We use our family wizard. We're ordered to use our family
Oh,
wizard.
okay. Then I'll grant this, but in the, while this is going on in the meantime, why don't you two start broaching a discussion about the future when these funds run out again, or when the parties feel it's right, and both parties, then maybe it can be supervised in the community, and then you should propose who would do that, and where it should be, and that type of thing. All that should be discussed, but I'll give you kind of some breathing time to do that. And I'll grant your motion to do the grant. I'll think I got to reappropriate that. So we'll go ahead and do that. I want people to have contact with their children. Anything further, Ms. Lang?
No, sir. Thank you, Your Honor.
Mr. Creepy?
I do have, I would like to see some clean drug tests or involvement in some kind of recovery program, and less or preferably no involvement with law enforcement. But yes, I'm open to all these things.
Put that all in your discussions in Family Wizard, because
Yes,
I
sir.
don't think they're particularly unreasonable. But I also want to see everybody move past, because Journeys was only ever supposed to be a temporary fix until things are done. And I understand, like I said, sometimes you go backwards a little bit, but we'll do it this way. And if you two can at least start the initial discussions about having this supervised in the community and by whom, I agree with Mr. Crafey. It's a lot healthier for the kids, and not as sanitized. I mean, no offense to Journeys, they do a wonderful job, but it's a lot different sitting at Journeys than sitting at McDonald's or something.
Certainly.
Okay. Thank you both. Have a wonderful 4th, and I'll do the order today.
Likewise. Thank you.
Thank you, sir.
I'm sorry. You did want me to draft that order for you?
No, I do. I'll do it.
Thank you, sir.
Thank you.
DeBryan versus Smith, no appearance by the defendant.
So didn't I hear this back in October?
You did.
Why
So
are we?
I'm not sure why we're here again.
Why are we?
I don't know. I think perhaps the reason was because the monetary amount was wrong.
What did I award you?
I never received any final paperwork on what was awarded. So when I went
Oh,
back,
do you know why?
they said that.
Oh, do you know why?
No.
Because you have to prepare that.
I did. It's all written in the new judgment, the new motion for money judgment.
Okay, so what is the full amount?
The full amount that he owes me is $194,845. Well, that's the. I'm sorry. Yes, that's the full amount that he owes me. I think where the discrepancy was that we had originally had the monthly lease that he owed me. We only had it in as 1 month, but it's for like over 4 years, so that had to be adjusted.
Okay. Then tell me how you let him know what we're doing today.
Tell me how you let him know what we're doing today.
I have had to I've had to mail him all of the paperwork to his last known address.
Which is your address, right?
Which is your address, right?
It is. There is nobody knows where he is. He several years ago emptied our bank account, was here one day and gone the next. No one has heard or seen from him since. During the divorce, he did somehow find out who my lawyer was and contacted her.
Hang on a second. Let me see if I can impose on my clerk to
See if I can impose on my clerk to
check that, or do we need another
check that, or do we need another
avenue?
All right, say that again. I have her muted.
I need to know if we have a current address on Chad Smith.
I have. Most recent I have is 945 4.
Then thank you. Then that's the only address we have. Mr. Bryan, you can prepare an order for that.
Brian, you can prepare an order for that.
For that full amount. And I will sign it. Can't hear you.
Okay, how do I go about doing that?
Nah, this isn't a legal self-help school.
How do I go about doing that?
Self-help school.
Okay, but this is the same conversation we had last time, and I had to
Yeah,
go to
exactly. See,
legal aid, and they told me.
Yeah, exactly.
And they told me that's why we have another hearing.
you go to the legalist. The first thing you should do is hire an attorney. The second thing you should do is, if you don't want to hire an attorney, you go to the Legal Assistance Center and tell them you need an order granting your motion for a money judgment in the amount of whatever you gave me, 194 and some change. And you send that at his last known address, which is yours. And then if no objections are received within 7 days, I will sign it. And then we're done. But it's a lot of money to be winging this on your own, Mr. Bryan. You might want to get some help, because once you get a money judgment, as I told you, it's just a piece of paper. Then you got to go about collecting it, and that might be the biggest hurdle of them all. So I wish you luck with that, but I'll sign that. Okay.
Okay. All right.
You're all
Thank
set
you very
with
much.
me. You bet.
Okay. All right. Thank you.
You
Bye-bye.
bet. So I want to let you both in on a little fact. Okay. There are people who have these types of cases who haven't ever had to go to court. Ever. This is the 5th motion that I've heard from you two in about a year. And that's way too much. Way too much. Okay. So this one is interesting to me because this motion was previously set, and I read it, Mr. Carter. Did you get a copy of that, Ms. Starks?
We did.
Okay. This motion was previously set for a motion on child support on the 20th. In fact, like I said, this has been the 5th motion since April 26th. It's also not in proper form, Mr. Carter, because I don't know if you are aware of this, but there is already a judgment or a order in place already. Do you know that?
No.
Is Mr. Gordon still representing you on this, Ms. Starch?
Yes.
Well, I can't go forward without him. Did you let him know about this?
Yes, he's aware.
Okay. I don't see him in the waiting room at all. Huh. Well, I can't hear without him, Mr. Carter.
Okay.
So, and I would also suggest that if you come down to the courthouse, they will give you or let you look at your file because there's already a parenting time order in place granting the parties joint legal and joint physical custody. And then it goes through a whole big parenting time thing. And that was entered by the court on March 18 of 2025. Okay. So
Okay.
you got to read that. And then did you send a copy of this to Mr. Gordon?
A copy of my motion?
Yes.
Yes, I did.
Okay. Did he contact you, Ms. Starks?
On the motion, no.
Okay. So I can't proceed because Ms. Starks is represented by an attorney. So I'm going to adjourn your motion without date, but I want you to come down to the courthouse and look at the March 18, 2025 order, or better yet, contact Mr. Gordon's office and have them send it to you.
Okay.
You should have a copy. And you need to read that before you come in again, because the only thing I can do is I can say, okay, tell me what has changed since March 18. And that's all I can do. And if I don't find there's been enough changes, then I'm going to deny the motion. But it seems like to me, you weren't even aware that there was an order.
No, I wasn't aware.
Okay, so you got to tag. Go ahead, Ms. Stark.
I'm sorry. I did send it to him via text and an email, just so he had it, so he knows that what the new motion is.
Well, I know, see, I signed it on March 18th, and so did Judge Gottlieb. And that's the final order of these things. And if you look at that, it sends you to Exhibit A, which is a very detailed parenting time schedule. So what you guys need to do is you need, especially you, Mr. Carter, if you want to file a motion saying things have changed since March 18, 2025, I'll certainly listen to it. But that's the order in place right now. And before you bring that, you really need to see that. So, Ms. Starks, can you, do you have Mr. Carter's address?
Yeah, I do.
Okay. First class mail it to him, will you please?
Yeah, no problem.
Okay. The order and it has an attachment because it has an Exhibit A.
Are we supposed to be following it right now as we speak?
Yeah,
Like it's supposed to be getting followed. Okay.
Fine.
So
that's what we're going to do. If you want to bring it back to me, Mr. Carter, I will listen to what anybody says on this thing, but I can't proceed without Mr. Gordon here. And I want you to have the full picture before we go any further. Okay.
Okay.
You're all set, both of you with me. Nice to see you again.
Nice to see you as well.
We're adjourned. All right, first on my screen, Cameron Atkinson, the plaintiff in this matter. Mr. Atkinson, good morning.
Good morning, sir.
Next on my screen is Miss Mina Cavazos. Miss Mina Cavazos, good morning.
Good morning, Your Honor.
I have received a motion from Mr. Atkinson requesting, it's labeled a motion for custody. I don't necessarily know if that's really what it amounts to, but
No, I didn't know what to name it, Your Honor.
okay. Did you get a copy of that, Miss Mina Cavazos?
Yes, sir.
Okay. Is there anything you want to add to it, Mr. Atkinson, before we hear from Miss Mina Cavazos?
Yeah, just that I'm just a little bit confused because she's indicated to me a couple different times that she'd be willing to go downtown and voluntarily alter our order. But then when I tried to do that with her, she would like flake or whatever. So I'm just trying to get like clarity on that, and then possibly find a way to go about doing that.
Well, that's interesting because as I read it, what it really contends is you want me to enter an order restricting the presence of third parties during periods of time when the children are with both of you, right?
Correct.
Okay. And one of the questions I always ask people that ask me that is, how do you wish to ask me to enforce that? Do we put up cameras in everybody's house and make sure nobody's sitting with somebody? How do we do that? How do we enforce that?
The enforcement would be based upon reporting, I guess, based on what is seen, done, and because this isn't like a private thing, it's a public thing. Like, she brought some random guy to my son's football game, and that was very out in public, and it's like a whole thing. So me and her, we go back and forth. Sometimes we on the same page, sometimes we not. Sometimes we cool, sometimes we not. And when she decides she wants to do her thing, she's like, F you, I'm gonna do whatever I want. But it's directly affecting my kids. They keep coming to me, asking me all these weird questions and saying all these things. And I put it in the order. The whole reason this is a thing is because we had an incident in our family about a year and a half ago, and me and her had extensive conversations about keeping our children shielded from outside influences. And when she decided she didn't want to do that no more, she just changed up, and it's directly affecting them. My kids have come up to me a bunch of times telling me different stuff.
Okay. Miss Mina Cavazos, your thoughts, please.
I think it's very unfair that he can state that. Our oldest son is the only one who's uncomfortable with my new relationship since I decided I no longer wanted to be with his father. There's too much bad there, and I don't want my kids to see how he treats me, that it's okay for them to be treated that way. So I decided I was going to leave him alone. A month or two goes by. I started talking to someone else. My son is the only one who felt uncomfortable and said he doesn't like it because he doesn't want someone to replace his dad. I explained to him that cannot happen. It will never happen. I've also told my oldest daughter that if she's uncomfortable at any time, the person's out of the picture. It'll go back to just me and the kids. No one feels uncomfortable other than Cameron because I am no longer messing with him.
Okay, so normally when I get these, once again, these become enforcement nightmares. The only thing that ever made sense to me is because how can anybody restrict people from showing up at baseball games? I can't trespass them away from those things. And if Miss Mina Cavazos is going to get to a serious relationship with this, then the kids are going to have to get used to it. Because obviously, if either one of you remarry, I don't know, are you remarried, Mr. Atkinson?
No, never.
Okay. All right. When one of you starts dating somebody or marrying somebody, I can't keep them out of the picture. The only thing I can do is say that I don't want any overnights in front of the children. Okay.
Thank you.
That should be something both of you agree to anyway.
No, not her.
So I don't, you can prepare an order, no romantic partners overnight in front of the children. And
Okay, and then
I'm not going to limit the rest of it. There's no way. If he wants to
That's
go to a baseball game, if he wants to go to a football game, if they want to go out to a movie, so be it. But
No, that's fine. She wouldn't listen to it anyway, but the overnights is fine. Is that the same? You said order? I just got to file an order.
you got to prepare an order, and I will sign it. But that's as far as I'm going to go.
That's fine with me.
Miss Mina Cavazos, anything further?
No, sir.
All right, prepare that order, and they'll show you how to get that to me, and I'll sign it. And
Thank you.
just remember, if these things blossom into, more commitment, like
That's not gonna happen.
fiancés and married, who knows? So we're adjourned. Thank you both, and have a wonderful 4th.
Thank you. You too.
Burrell versus Kuykendall.
All right, first on my screen is the defendant in this matter, Mr. Kuykendall. Mr. Kuykendall, good morning. Press that little red microphone. There you go.
Okay.
Good morning.
Good morning.
And next on my screen is Passaniqua Kuykendall, or Burrell, I'm sorry, I got the wrong name. Miss Burrell, good morning.
Good morning.
So this is your motion, Mr. Kuykendall. Before we go further, Ms. Burrell, I can't have kids in these hearings, okay? Especially ones that make too much noise. And it's not his or her fault. It's just that's gonna mute out microphones when they speak. So it's I don't want to have any problems with that. Okay, I think we're all good. So you have filed a motion, Mr. Kuykendall, to object to the friend of the court. Is that what I hear?
Yes.
Okay. Now you understand something. When you object to the friend of the court, then I hear the case from scratch with the friend of the court there as well. And
That's okay.
You could end up in worse shape with me than you could with what the recommendation says, but that's a calculation. I just want to make sure you understand that that's part of the risk of objecting to the friend of the court. Okay.
I understand.
Okay. And Ms. Burrell, you received a copy of his objection?
No.
Did you send that to her, Mr.
Yes, I
Kuykendall?
did.
Didn't get it, Ms. Burrell?
How did he send it?
I think on your address on Eastern.
No, I didn't even get a notice of this court date other than through text message.
Well, then you got a notice of this court date.
Okay, well, yeah.
But you no longer live on Eastern?
I do.
Okay. I'm trying to figure out why you didn't get it. Did it come back in the mail, Mr. Kuykendall?
No, it didn't. No, it didn't.
Okay. Well,
I for privacy reasons, I never put my address on. I always mark it off, but I did first class mail, so I don't know how she didn't.
Well, did you go to the post office and get the right postage?
Yes, I did it a couple of times before. I did it like I always do it. I did it in I mailed it out in South Bend, Indiana, though, but I always mail it out from South Bend, Indiana.
I don't know. Do you have an email address, Ms. Burrow?
Yes, but I'm not giving it to him.
Okay. So how do you two coexist with children and you won't let anybody have your emails and phone numbers and addresses? What are you guys in the CIA? What's going on here?
Respectfully, sir, I am concerned for my safety. I'm being harassed and stalked.
You
So
have a
I would
PPO?
rather go through a third party, as I stated the last court hearing. I would rather go through a third party, whether it's with the courts or through his mom. Outside of those two people, then I just rather not have any type of communication.
Do you have a PPO against him?
I tried. You guys denied it because there's
Don't say you guys. Don't say
The
you
courts
guys.
denied it because we didn't have a order in place for the kids.
Okay, that wasn't me that denied that, just so you know.
Yeah, I know. Understandable. Yeah, I get
Okay.
that.
So then the only thing I can do is if he has your address, he has filed an objection to the front of the court recommendation. Did you get the front of the court recommendation?
Mm-hmm.
Yes?
Yes, sir.
Okay. So what you may have to do in the future, Mr. Kuykendall, is your address confidential at the court, Ms. Burrell?
No, not as of right now, no.
Okay, you can file a request for a confidential address, and then the way you would serve her, which would kind of be easier for you, Mr. Kuykendall, is you would bring it to the front of the court, and they would send it to her, and that way you could assure that she would have it.
Okay.
But you have to do the request for the confidential address first. Okay, Ms. Burrell?
Okay.
All right. So what happens when a recommendation from the front of the court is made, the parties can agree with it, and then they really have to do nothing. Then it gets entered as an order, or they can object to it, or they can try and work out their own agreement. I don't think that's even possible if the parties don't want to even communicate. So really that only leaves with that option. The third option, and that's I have to schedule an evidentiary hearing or a trial. So you both now have, my clerk will send out the date. There's very specific requirements. It requires trial briefs, witness lists, exhibits, being in a 3-ring binder. It's complicated. So if you both were thinking of continuing to represent yourself, you can do that, but it's very complicated. And if these deadlines that are filing deadlines are not met, then your case could get postponed. And I don't want that. All right. So you'll be getting a date in the mail and have your witnesses and all that disclosed, and then we'll hear it at that time. Okay.
Okay.
You're all set, both of you with me. We'll get you that date.
I have
All
a
right,
quick
thank you.
question. So there's nothing in order as of right now. So the recommendation from the court that's not in place right now?
Correct.
Okay,
It's
thank
just a
you.
recommendation from the front of the court.
Okay.
So, can I say one thing, y'all? So there's nothing in place. I saw my daughters one time in a year.
Do you see what you've done to yourself, Mr. Kuykendall?
No, I do.
See, if you would have just simply said, all right, it's not everything I want, but it's a start, then
It's not.
you
It's not a. I'm sorry.
could have got moving. But now you're
But
stuck. Now
it's
you're
not.
stuck.
It's not a start. It's not a start though. I have to. It says I get a couple hours at her house. That's impossible to do. So I don't
Well,
understand how that's a start.
well,
But I understand we're gonna do. I understand.
I'm gonna, after I hear the evidence, I'm
Mhm.
going to do or issue a recommendation also. So but I just want to make sure you have all the information. So I'll wait for that. We'll have an evidentiary hearing, and then we'll figure it out from then. Okay.
Can
No
I
problem.
say one last thing? I'm sorry.
You said I have one thing to say, and then
But
now
this
you have
is the
another thing
absolute
to
last
say?
thing. I promise. He just said that the order states that he has to have them at my house for a couple hours. That's not true. It states that he has to pick up and drop off from my house.
But you're talking about not an order. You're
But
talking
and that's what I'm saying. I'm willing to give him. I'm still willing, even without that being an order in place with the courts. I'm still willing to do that
I
if
would,
that's okay with him. But like I said, I only want to go through the courts and his mom. If we can't do that, then I'm okay with not being it being whatever it is.
yeah, I can't figure this out on a Friday morning. All I can.
I respect that. I'll wait till the paperwork come and we can go from there. Thank you.
Okay, sounds like a plan.
Dantzler versus Clark, no appearance by the defendant.
we were just saying that always works. I alluded to this last year, or last motion day. If there's ever a non-appearance, it's always by the person who doesn't bring the motion. It just works that way all the time. So, you are Ayana Dantzler?
Yes.
Good morning.
Good morning.
And I don't see Mr. Clark in the waiting room at all.
Yeah, he stated that he would not participate in anything regarding any court, legal, judge, nothing anymore.
Okay.
So
So he has a you have a confidential address. I see that.
yeah.
And when you let him know about this hearing today, it says you sent it to him or hand delivered it to him on July 25. Is that true?
So yeah, so when I went to deliver it, he refused, so I just mailed it to him.
Okay. When did you mail it to him?
I literally mailed it the same day. I went right to and did it first class mail.
Okay.
So he got it and he's aware of it. He said he's just not gonna
he doesn't want to
in
participate
doing
in
anything. So
okay.
yeah.
And I heard a motion on this back in May. And now we're here on parenting time. The last parenting time order was the judgment of support, which was dated in March of 2025. We can't seem to get launched on this case. And that was parenting time as previously agreed. So the parties can't agree on anything?
No, simply because like he wants to be above the law. Like he feels like he doesn't have to participate. He can do whatever he wanted to do. And all I'm trying to do is just get her a stable schedule so we don't have to have the mishaps and this, and that, and the back and forth. I'm tired. She's 4, like I'm tired.
So if we did, so if I did an order of reference to the friend of the court to have something called facilitative mediation, that's where the parties would meet with somebody from the friend of the court and they would hammer out a schedule. Is that something you think would be appropriate?
I actually just had that. Like, I think that was 2-3 weeks ago, and he didn't show up to that either.
Okay. Well, then I'll do, if you don't think that's going to help, I will do a full order of reference. That way it doesn't matter if he doesn't show up, then his views will not be taken into account. I am going to do something I never do, Ms. Dantzler. I am going to send it to the friend of the court for a parenting time investigation. I'm going to waive the fees. I never do that. Ask anybody. But I don't want anything to stand in the way of this getting done. If I split the fees, then he wouldn't pay and then we're back to square one. So I'm going to waive the fees for both of you. Okay.
Yeah.
You're all set then, and I'll do the order today, and you'll be hearing from the front of the court shortly.
Okay.
Thank you.
Kinch versus Kinch.
So this is a motion by Angela, it looks like, or no, it looks like, see, the plaintiffs are flip-flopped on this. Let me make sure I get it. This is a motion by Laura to remove parenting restrictions that are currently in place on parenting time. Angela, did you get a copy of that motion?
I did.
Okay. Anything you want to add to that, Laura, before we hear from Angela?
No, sir. Everything's stated.
Okay. Angela, your thoughts, please.
Thank you. I was a little surprised because we've been really good lately to receive this in the mail, but I did receive it. And to be honest, I don't have a ton of objection with it. Laura's done a lot of things well, and we've been working together fairly well. My only concern for the continued action, and I'm not sure how to move for that, is right after receiving this, unfortunately, just last Friday, the June 27th, we had gotten another alert from SoberLink that was a positive test. Though I know Laura, has always let me know that it's a false positive. She's following up with the SoberLink. I know she's had multiple conversations with them and looking at those pieces. I can't attest to I following the SoberLink, and so assuming as you watch those retesting every 15 minutes, as that BCA goes down, assuming that it's accurate and not a false positive. At the same time, they were out of town at that point, and I did confirm that she was in a stable position and I'm able to talk to my daughter. And so felt okay at that point, whether it was positive or false positive. Don't want to stand in the way of future therapy. I know I received her motion that with the piece with the counselor, if she needs other therapies, I don't want to stand in that way from an insurance perspective. My biggest concern is with the history of addiction in general, in the future, for safety wise, if I do have a concern, what would be recommended? Am I able to, if we don't do the SoberLink any further on a regular basis, if I do have a concern, is that something that I should, am I allowed to request a breathalyzer at that point, as having that primary custody? I just want to be able to keep, my daughter safe. And this was just one of the ways that we knew. So not trying to take away, anything. But I also want to know that with an addiction and as evidence that things do cycle sometimes, what it would be my way to protect.
Thank you. Was that another false positive, Laura?
Yes, sir.
Okay, and you're getting that documentation from SoberLink?
Yes, sir.
These are obviously tough cases. I know that SoberLink is a difficult thing, and sometimes there are false positives. I don't know. Life is not as cut and dry as they are if you're on probation for something. If you're on probation with something and you either miss a test or it tests positive, then obviously they treat it accordingly. I try and at least give people the benefit of the doubt. But I fully concur with Laura and Angela both, that obviously we don't want to stand in the way of this, and but there should be redress for in the future. So what I'm going to do is this. I will grant your motion, Laura, in part, and I will remove the SoberLink requirement at this time. However, if there is any evidence of alcohol use 12 hours prior to or during your parenting time, any evidence whatsoever, then Laura will have the opportunity, or Angela, either one of you will have the opportunity to bring that issue back in front of me, and I'll consider what evidence is there. And if it suggests that she utilized substances, then I will put the SoberLink back on. Okay. So
fair. Thank you.
I hope that, and addiction is a tough thing, and it's one of those battles that you fight on a daily basis, every day. It doesn't go away. So proud of both of you, really, for working through this. Proud of you, Laura, for your continued sobriety. I hope that that everybody can understand that while I like you both, my issue is the best interest of the child. That's what I'm here for. You two are adults, you two, but I'm interested in that. So if you want to prepare an order to that effect, Laura, you go to the Legal Assistance Center, and you can prepare an order that says I'm lifting the silver link requirement. However, if there's any evidence of any illegal substances or alcohol 12 hours prior or during parenting time, then Angela has the right to re-petition this court and ask that silver link be placed back on. So I need an order to that effect. And then once presented, I'll sign that. Okay,
Is that from Angela or Laura?
Laura, it's your motion.
Okay.
Okay.
Yep.
Well, that's from
And
me.
does that also count therapy? Because that was the court order too.
Yeah, I'm gonna, as far as therapy is concerned, I think it's mental health counseling. If you're, if you don't think, if the parties don't think mental health, because there's already a requirement in there, says paragraph I, mental health counseling. Plaintiff shall continue her mental health counseling. Defendant shall continue her individualized counseling, focus on substance abuse. The party shall continue this counseling until further order of the court or upon mutual agreement. Are you both agreed to that? That you both no longer need any of that?
I guess my specific question was to not have to see the therapist at Pine Rest for alcohol abuse. That I could pick a personal therapist and move on from that. I'm more than willing to do that, and I know that I need that in order to continue on my path.
This or Angela.
Yeah, I totally, like I said, I don't want to stand in the way if the focus needs to be shifted for therapy. I agree and appreciate the question of continued therapy, and I think for all of us is usually a helpful piece.
Put that in the order too, Laura.
Okay.
Okay.
Yep.
Nice doing business with you both.
Thank you, sir.
Thank you for your time.
Have a great 4th of July.
You too.
You as well. Thank you.
All right. First person on my screen is our defendant, Lawrence Webb. Mr. Webb, good morning to you. Can't hear you. Why don't you unmute and say hi? There you go.
Can you hear me now?
I can. Good morning.
Good morning.
Is it Alicia?
Yes, Alicia
Okay.
Houseman. Well, it's Alicia. Sorry.
Okay. And you go by Houseman, correct?
Yep, Alicia Houseman.
Okay. Ms. Houseman, good morning to you.
Good morning.
So I have received a motion by the defendant requesting that this court review the custody order, which was entered on November 16 of 2017, which gave the initial custody to Ms. Houseman. And according to the motion anyway, I'll tell you what I know. Apparently, at least it's relayed to me that the parties had agreed on some sort of week on, week off, but then plaintiff on her own changed it, now claiming that the child cannot see her father due to an incident in her father's home. So that's what I know, Mr. Webb. Anything you want to add to that before we hear from Ms. Houseman?
Yeah, this is about needing established custody because I've had my daughter for 10 years and I have not missed a visit. And the last visit, Miss Hausman made me miss, and using an incident that didn't involve her or our child to exert control. Uh, she, I was like, or that mother and I are fine, and my custody with that child hasn't changed. I need to make sure Miss Hausman can no longer use our child to try to hurt me. And that's why I'm here today. I'm a great father. I try my best. She got involved in something listening to my 10-year-old tell her what had happened and exaggerated it to try to have fuel against me. I just want what's best for our daughter. I think Alicia's a great mom, and I know I'm a good father. I don't know why she's coming at me like this, and I'm just here to get my rights with my daughter. I don't like feeling controlled. I've kissed her butt multiple times. I've tried to make amends for past stuff that's happened with me and her because things got really toxic. I've went and let out her dog for her. I've when she made promises to my daughter at her school that she promised her a Sprite, I bring that. I do that. I don't get why, I'm able to discipline, which that's what had happened is I ended up disciplining my other daughter. And it got back to her mom, and then she's stating that I can't see my daughter because of it, and the other mom is fine with the discipline action. I filed a motion. She ended up calling CPS and stuff after the fact. If it was a concern, she would have called them beforehand, and that's where we're at.
Okay, so you're kind of so you got two exes, and you're kind of fighting a two-front war, but one of them is a little, from your perspective, is easier for you to get along with.
Yeah, we communicate really well, Your Honor. We go to soccer games together. Usually I communicate with Mrs. Hausman, but when things don't go her way, it's like it's I get attacked. If I yell at my daughter and she goes back there crying, she threatens me over and over again that I can't see my daughter, and it's hurting my daughter. My daughter cried to her oldest sister the other day saying I never not wanted to see dad. Yeah, she was distraught that her sister got a spanking. Her sister got a spanking because she's been really disrespectful lately. And her mom was happy that I seen it at my house and that I had to handle it.
Okay.
And
I think I got the picture. I got the picture. I got it. Ms. Hausman, your
Yes.
thoughts, please.
What was that?
Your thoughts, please.
I went to FOC yesterday and wrote my statement, and I have it in front of me. Could I read it?
I would appreciate it if you would just tell me what it
Okay.
says. I don't need you to read it.
Okay.
Because
Okay. Our daughter, sorry. Our daughter JC is my biggest concern, her safety. He has a very violent past with violent crimes, especially I mean, I can't base this on 9 years ago, but it did happen to me. And he did get charged. Since then, he's had other violent crimes with other people. And my daughter has come home every other Sunday night, a few times this year, scared, trembling, crying, saying that, there was an incident where he might have broke a dog's ankle because he got mad at the dog. Or it's a lot of rants and walking on eggshells. Just like we went through years ago. It's the same thing, same pattern. What my daughter tells me every other Sunday night is scary. This June 8th, when she came home Sunday night, crying and trembling, Lizzie was still crying in the car. She explained to me that Lizzie had too much ice cream, one too many, or two too many. And she nodded her head to him. And he still took her to the room. A closet was broken, marks were left. My biggest concern is my daughter will not be around that. My biggest worry is when she hits puberty, like his 13-year-old did, and she gets a little sass, what's going to happen to her? Because these female hormones and like in a household is not good for him. He has no patience. He is he's dangerous. I don't like his criminal background. She's told me that he beat up his little brother right in front of her. she's around, she sees fights, she sees arguments, and it's toxic. And I'm worried about her when she hits 12 or 13. And I know I've tried, it's been very hard to co-parent with somebody who assaulted me 9 years ago. And I've tried, and every other weekend, faithfully, he sees her. If he wants to see her during the week, I never said no. But when my daughter's venting to me about this stuff, it worries me. It worries me to be in a home and walk on eggshells every other weekend with him.
Okay.
And I have pictures and documents as well here. I'm at the courthouse because it said nothing about Zoom, but I'm in a conference room. But I have all my stuff.
Yeah, I do everything by Zoom.
Okay.
Everything. So just note that for your for future consideration.
Okay.
All right. Well, I can't figure out this dilemma on a Friday morning. I need an investigation.
CPS case is open.
Yeah, that CPS, I get that. They have a job to do. But they don't they're the agency put on this earth to look out for children. So their interests sometimes diverge from mine because I have always my focus is on the best interests of the children. And I always have to weigh that as to the constitutional right of Ms. Hausman and Mr. Webb to parent their children. So it's kind of it's balancing it, okay? The first thing I'm going to tell you is I don't find that proper cause or change of circumstance has been shown to change physical custody of this child. That's pursuant to the threshold of Vodvarka versus Grassmeyer 259 Michigan Appeal 449, a 2004 case. However, the Michigan Court of Appeals stated in the case of Sims versus Verbrugge, that's found at 322 Michigan Appeal 205, a 2017 case, that when the initial custody was not judicially determined, it was determined in the physical custody was, not the legal custody. And there's a difference between the two. Physical custody has more to do with where the child lives, resides, stays with. Legal custody is the ability of the parties to be consulted on major decisions and be informed of health, safety, education, welfare, those types of things. And the Court of Appeals, in their wisdom, has stated that since legal custody was not judicially determined, that Mr. Webb does not need to show proper cause or change of circumstance to open that issue up. So what I'm going to do is I'm going to refer the issue of legal custody, parenting time, and child support to the friend of the court for investigation and recommendation. Ms. Hausman, are you currently working?
Yes, I've been working, and could I say a few more things as well?
No, I don't really need any more because
Okay, I've been working.
That's what I'm going to do.
Okay.
Mr. Webb, are you working?
Yes.
Okay. So I'm going to reopen the issues of legal custody, parenting time, and child support. The fees for that will be split, so make sure the friend of the court has your correct information because they don't forward mail. And I'm going to ask the parties to keep this, whatever schedule now they had or they have, if it's alternate weekends or whatever, until the friend of the court gets in and squares this up. Because I do think parenting time needs to be set. because it was never set. And I think the parties need to have an order in place governing everybody's conduct and other things. I've been known, if there's an anger issue, I've been known to order anger management. There's a lot of things, but I want to hear from the friend of the court first. So I'll prepare that order today, and you two will be all set. And just if you have any doubt as to whether the address is, they don't have your correct address, you should reach out to them because they don't forward mail, and I don't want this thing stopped. My clerk also needs something from you.
When we're finished here, I'm gonna need, I don't have an address or a phone number for Ms. Hausman.
Okay. All right, well then, why don't I disappear? You take us off the record and Ms. Hausman can give you that. Well, we're not on the record. I will do that order today. So thank you both very much. I wish you the best.
For sure.
Figure this out. The plaintiff in this matter, Jenny Shepard. Ms. Shepard, good morning.
Good morning.
Next on my screen is the defendant in this matter, Chris Shepard. Mr. Shepard, good morning.
Morning, sir.
And next on my screen, on behalf of the plaintiff in this matter, Attorney Stephanie Judd. Ms. Judd, good morning.
Good morning.
So I have a couple of matters. First, I'm going to somewhat take them out of order. I received a what amounts to an improperly filed motion to adjourn. Did you get that, Ms. Judd?
I did.
Okay, I want to cover that first.
Of course.
So if you want anything you want to add to that, and then we'll hear from Mr. Shepard.
I would add that Mr. Shepard was served properly in accordance with the court rules. I didn't mail it. I emailed it, which is authorized by the court rules. So he was provided with 8 days notice via email. And Monday was the first I had heard from him. So I'm not sure what basis there is to an adjournment, but I can get into obviously the requested relief and knowing that the court's not permitted to change the schedule today. So I'm not sure what the additional time would be, but the next hearing date with the court isn't until August. So I am opposed to an adjournment for obvious reasons as outlined in the motion itself and would prefer to proceed today.
Thank you. Mr. Shepard, I'll give you the floor, but I just want to tell you that the motion must be filed, any motion must be filed at least 7 days before, and service, if by mail or email, it usually has to be there anywhere from 7 to 9 days before. But I'm trying to think of what the puzzling thing about your motion and what I didn't understand, and maybe a good launching off point, is paragraph 3 of your motion, because I read it. And it said that you got an email on June 25 from Ms. Judd, but you chose not to open it until the 27th because you are away from your computer. And I'm kind of befuddled about that. Why would you get an email from, I mean, getting an email from an attorney is about as unsettling as getting an email from the IRS. And I wouldn't think you would just simply say, yeah, I'll open it later. But go ahead, I'll listen to you.
Yeah, when I said I did not open, so I opened the email the evening of June 27th. When I looked at the email, it was dated for June 25th. So I didn't open it on June 25th. You can see from probably email records of when I opened the email, but it was on the evening of June 27th. I'm been working in the late afternoons and I had my kids that day, the day before. So again, I didn't open it till the evening of the June 27th. As soon as I did go to the court the next day. And well, first of all, I was trying to find an attorney to get legal counsel, and I was having a difficult time doing that. And then so I went in to try to ask as soon as I could to ask for an adjournment, which wasn't able to do the first thing Monday morning, the following Monday morning. And trying to get legal counsel for the past 3 days, and because of the short holiday week and just such short notice, I wasn't able to obtain legal counsel.
So, one of the things I did notice, because I wanted my clerk to, I asked my clerk, after I got your motion, to read me off the address that the court has for you. And that was 1845 Flowers Crossing. See, that's the problem, is when you move or something along those lines, it's no fun unless you let the court know. And that was, I think that's been corrected as of now, but that's the last known address that the court had. And technically by court rule, all the attorney is required to do is send it to you at your last known address. Can't help it if you actually get it or get it 6 days before. That's something that you really could have got it a little bit sooner than that had you opened it on the 25th, right?
Yeah, it was she sent it the evening of the 25th.
Yeah. So I'm just saying that
and because of work and then having my kids, and the next day I had work all day, and then I had my kids through the evening. I don't just check emails every day.
Well, I would if I got one from a lawyer. If I get one from a lawyer, or
I haven't got anything from a lawyer in a long time. So
I'm with you. Well, also your motion is not even properly filed.
Well, again, I try to get legal counsel, but I'm not an attorney. I didn't know that. As soon as I had the opportunity, which was that first Monday morning, that's when I submitted for an adjournment.
Yeah, I know you're not an attorney. I know you've had an attorney in the past, I believe. But with that being said, the motion's not properly in front of me. And I'm going to respectfully deny the motion to adjourn because it's not properly in front of me.
Well, all I can say is that, I mean, this is a very high profile case. There's a lot of claims regarding the best interest of my kids. Like, this is, it needs to be done at a very high level for the best interest of my kids and prepared carefully. And because of there's false accusations, there's concerns with
well, let me get you straight first. Let me get you straight first. Whose false accusations? Miss Shepard, Miss Judd, or your kids?
Miss Shepard.
Okay. All right. Okay. So
there's a lot of again, this is a very complex matter, especially when it's pertaining to the custody of my kids. We can have a really detrimental mental health status with me potentially losing custody of my kids, and this needs to have proper legal counsel to not only gather the supporting evidence to counter her claims, which takes a little bit of time, but again, to gather supporting evidence and to have, again, proper counsel and defending these accusations.
Okay, thank you. All right, let's get to Ms. Judd's motion, please. I read your motion, Ms. Judd. Is there anything you would like to add? I do have a few questions for you after you've said what you're going to say.
Of course, I tried to be thorough in the motion itself. I guess I wanted to just address one comment that Mr. Shepard made. I do not believe he didn't get the email until the 27th. I sent it to him on Wednesday night after my client had secured the children. And I did that on Wednesday so that the children would be with her when Mr. Shepard received the email. I'm fairly confident that he had received the email by the following night, as he had then on Thursday taken it upon himself to have the children playing a first person shooter game, having them pretend all the enemies were NP, my client's paramour. This has escalated to a really concerning level, and I'm really worried that somebody is going to get hurt here. So I'm trying to be thorough and forthright in my disclosures. This was originally accompanied by an ex parte request, which was denied with a suggestion that CPS be utilized. But my client has utilized CPS. They've been contacted 3 times now by the child's therapist, the eldest child's therapist, to no avail. I read that myself in the therapy notes. I did not disclose all of the therapy notes. I quoted some significant portions of them, but I'm trying to respect these children's privacy. And I suspect that CPS isn't stepping in because a majority of this is psychological, less the admitted slapping that was littered throughout the therapy notes. I've got a nearly 10-year-old girl now without a bedroom, reported to her therapist to be sleeping on a kitchen floor. So something needs to change here. My client does not want to cut Mr. Shepard out of these children's lives, but he's not participating at all in their therapy. I think this has become somewhat of a game, but these kids are suffering. These kids have now documented disorders. They are scared of him. They are being harmed in his house. And he's on some crusade here to ruin my client's life and her paramour's life at the expense of these 3 children who all they want to do is have a relationship with both the parents. The therapy notes were terribly sad. At such time as we have a hearing, I suspect all of this will come out. But these kids are terrified. They're terrified of the situation. They're terrified of retribution. They're being physically disciplined as a result of all these disclosures to their therapist and to my client. And Judge Gottlieb has already given Mr. Shepard a stern warning to move on. Let it go. The divorce has happened. My client has moved on. Everybody can move on and be happy. We just need Mr. Shepard to get on that train. And I'm not sure what the roadblock is here, but I think we need to look into the root of this concern, because his taking his anger out on these kids is really escalating to a concerning level. I think at a minimum, we need to implement a supervision requirement. Until we can get into this, I think it would be imperative for him to participate in their counseling for once, so he can hear firsthand what kind of psychological trauma this is causing to the kids. And I would also request verification from a medical provider of some kind that he's even cleared to drive, because we've got a history of intermittent seizures. I don't know if he's being cared for properly by a medical provider. I have no idea if he even is cleared to drive. I'm not sure if he's had subsequent seizures, but like I said, I'm really worried here that somebody's ultimately going to get hurt. I would prefer that not to happen. So my client has turned to this court for relief.
Thank you. The question I have is, and it's somewhat concerning, when I read your paragraph 53 in your motion, I became concerned, because what that tells me is that the only reason that your client agreed to a consent judgment of divorce was with that paragraph in there. And that seems to run afoul of when they raise the right hands and tell the referee or judge that this judgment is in the children's best interests. Paragraph 53 somewhat indicates that it's not, that it was only done out of convenience by your client to get this done, and I'm troubled by that.
Oh, I certainly didn't mean to suggest that, Your Honor. I was suggesting that it was important to Mr. Shepard to have the label of being a joint physical custodian. And despite the reality of the schedule operating in a manner that had rested physical custody with my client, At such time as the mediation was happening, we all just agreed to have the label of joint physical custodians, with everyone being on the same page that we didn't have a joint physical custody arrangement. The parenting time schedule doesn't dictate a joint physical custody arrangement. And subsequently, because of her attending the medical appointments, her spearheading the therapy, her spearheading the school activities, she really is the primary custodian. I had referenced that merely to address the burden here moving forward. I certainly didn't mean to suggest that my client had created any kind of false impression to the court. The parties were getting along a little better at that time. And like I said, in the judgment, there was intention of expanding the schedule. So it was anticipated that perhaps the parties would be joint physical custodians if Mr. Shepherd did the things that he was supposed to do. But that didn't happen, and time had passed. So the circumstances have really created a primary physical custodial environment with my client. That's what I had intended to suggest.
Also, the last question I have, and then we'll hear from Mr. Shepherd. Why hasn't, maybe he has, I don't know. Why hasn't NP gotten a personal protection order?
I believe he's in the process of doing that, Your Honor.
Okay.
And frankly, the answer is everyone's been trying to keep the peace, but
yeah, that would be because I don't know about your initial thoughts, but a PPO against a is it a live together partner or not?
it is as of recently, and that's what has sparked the escalation and the comments to the children.
Because that could sure complicate the.
And that was yes, and that was the other reason why there was hesitation, because I mean, my client, frankly, like I said, has been at war with herself as to how to handle this, because she's trying to keep the peace. She genuinely wants to be able to get along for these children, but I'm not really sure what else she can do at this point.
No, I think if these are true, and I don't know if they are, I'm just going by what I'm hearing. And that's why I asked Mr. Shepherd, who's not being truthful, because obviously these threats are, at least alleged threats, are being made from the children. So I guess it would mean that the children are not being truthful, but we'll cross that bridge when we get to it. But I think NP, I don't represent him. You don't represent him. Nobody does. But if these are in fact true, then he should approach the Personal Protection Order Office. But Mr. Shepherd, your thoughts, please.
Yeah, there's a lot of points to go over there. So, yeah, excuse me if I jump around a little bit. I was actually on call last night, working
Me too.
in the morning on a mental health case. So, first thing is, there's a history here of parental alienation that I originally presented to the court, but evidence wasn't allowed. They did not want me to allow me to present that. First of all, our daughter, let me get my notes here. So first of all, our kids do have an adjustment disorder and do have anxiety, but there's a lot of factors that affect that with children. Our daughter has a very high genetic and environmental risk for anxiety. In fact, clinical literature shows that she has an 85 to 90, between 80 and 90% chance of predispositioned anxiety because of, first of all, Jenny and I both have a history of mental health disorders with anxiety. When you experience multiple residential moves, when your kids do have issues with learning, all of these things in conjunction, give you a high disposition of having anxiety. So there's a lot of other factors that affect, our children's mental health that are not being, discussed and then you throw in, you know, um, having, there's basically research showing that introducing a step parent as a parental father figure to your children early on before the age of 6 can have a mental health effect for your children. There's been 2 instances where my Jenny has, um, you know, tried, done emotional damage to my kids by, um, like, okay, for instance, like bringing him to games and having him take my kids to like their events, which should be done by the primary, like the both primary parents. Um, you know, having the boyfriend take father-like pictures and then exposing them to me, and my kids. Just when you bring in a secondary father figure early on in a children, that can cause, um, again, that can be a factor when you're, looking at, the effect of the mental health of a child.
I understand that.
The
Let me
other
ask you
thing,
this. Well, let me ask you a couple of questions and see if we can't.
can I say one more thing really quick before you comment?
If you need to.
Yeah, so the next thing too is there's been a lot of gaslighting that has caused anxiety and fear in my children. So for instance, in the letter from the behaviorist, first of all, there's misinformation in there. Um, my Jenny, I don't have epilepsy. I did have a seizure in November of 2022, which was documented. My doctors have, um, made a clinical decision that that was a drug-induced seizure. Prior to that, I did not, and I've been medically cleared. We fixed the problem. I haven't had a seizure since. I didn't have a seizure in December of 2024. I don't know where she makes claims on that. I did pass out, and I was on a diet in December where I was fasting, and we believe from what, um, a family member at my house thought that I passed out, and it could be related to my diet. He did not say I had a seizure. Jenny just assumed I did. And prior to that, I didn't have any seizures for the last like 3+ years. But Jenny wants to portray that I did and gaslight my children in being fearful that I'm not healthy, that I have seizures, and are scaring them where I don't have the ability to drive with them, and when I've been clearly, cleared by my doctors, and I've shared that with Jenny that I've been cleared. I have been seeing a doctor. There's no medical reason why that could cause a fear here, but she keeps gaslighting my children as part of her alienation tactics to, again, put her in a better position than me, and try to, again, reduce my fathering. I mean, in the past, she has stated that she was going to ruin my life. When I said I eventually wanted to get full 50% custody of my children once we made some changes in my household regarding the bedroom status, she said, no way, like that's not going to happen. The kids need her mother.
Okay. I've let you go for quite a while now. When you said there's one more thing, and then you proceed to talk for 15 minutes.
Sorry.
So let me ask you this. You can understand, can you not, that the fact that you had 2 episodes while you were driving, and whatever you want to attribute those to.
I never had one driving.
See, that's what you can't do, Mr. Shepard. When I give you the floor, I give you the floor, but you can't interrupt me. Okay. that would be a nightmare today.
Sorry.
So, but having these types of seizures anyway, whether they're a seizure, whether they're a vent, and I really don't care what caused it, because the paramedics won't ask what caused it when they're digging you out of a car if that happens again. So I think, first of all, and you can put this in the order, Ms. Judd, I want a recent medical clearance that you are able to drive without restrictions. That's number one.
Perfect.
The second thing is, I want, certainly in my view of reading all of this, all I need to do today, and there's been a lot of psychological terms bantered around today without, quite frankly, any supporting proof of that. Gaslighting, parental alienation, those things are becoming mental health issues now. And I wouldn't know that. But the motion asks for a change. And in order to do that, I need to assure myself that there's been proper cause or change of circumstances pursuant to the case of Bodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2004 case. And they can't just be any proper cause or change of circumstance. They must be things of significant magnitude that could have a significant effect on a child's life or well-being. The matters listed in the motion include the fact that, one, you no longer participate in therapy with the children. Two, the inappropriate behavior in front of the children starting in 2023. Threatening plaintiff's partner NP in front of the children, that's the allegation. Four is the children's fear of the defendant. I don't know what that's all about. And the whole concept of driving with the children, it could cause an issue. I don't know if any of those are true to the certainty that's required to change custody, but that's not my job today. My job is only to find whether there's been proper cause or change of circumstance to at least stick my nose back in it. And as Ms. Judd knows, I don't like to do that at all. But in this case, the relevant best interest factors are found at MCL 722.23, and they center around factor B, the capacity and disposition of the parties to give the children love, affection, and guidance. That's particularly the mental and physical health of the parties involved. And this whole concept of, they've really expanded the definition of domestic violence. I'm not so sure that if these allegations are true, that threatening these types of behaviors against NP would not amount, in this case, to the expanded definition of domestic violence. So, but I don't know that, and we're going to get to the bottom of all that. So I am going to grant the plaintiff's motion in part. I am going to first require that Mr. Shepard provide Ms. Judd with a copy of a very recent doctor's note that
perfect.
At least claims that, or at least states that you are free to drive without any type of restrictions, And it might be a good idea to have that physician or whoever acknowledge that you've had these issues in the past and that they've been rectified. I'm also going to order that the friend of the court conduct an investigation and evaluation into the concept of custody. The fee for that will be divided between the parties, $150 apiece. I am going to take under advisement the other relief requested to and including eliminating overnights. If things continue, you can bring that back to me again, and I'll present an interim order, Ms. Judd. But that's what I want to have at least initially. And we'll see where we go from here. And you'll have plenty of time, Mr. Shepherd, to contact legal counsel of your choice. And I don't think we've done anything that would implicate the custodial environment at this point. So I think you're okay from that standpoint. Is there any questions, Ms. Judd, on what I need the order to say?
I just have a question, Your Honor, just because I've had this happen a couple of times now. I'd prefer the order reflect that my client pay the full fee and Mr. Shepherd reimburse her his half, if that would be acceptable, just to prevent any administrative dismissal in the event if it's not paid.
That's fine.
Okay, that's the only question I have.
I'll do that. And then you can just pay, send a check to Ms. Judd's office, Mr. Shepherd, for the $150. And Ms. Shepherd can pay the fees. And we'll see if we can't get to the bottom of all of this. And I take it if, some of these things are very disturbing, and I hope that I hope that if they are occurring, they stop, because the last thing in the world you're going to want to do, Mr. Shepherd, is have a three-front war between you and your children. That would be very detrimental. So I will do that order of reference, Ms. Judd, today. And is there anything further from your end?
I have obviously some comments to what Mr. Shepherd had alluded to with his seizure, but we've taken up plenty of time. We can address that all in the future.
Thank you. Mr. Shepherd, anything else I can do for you?
So is there a change of custody then?
No.
So I keep my children during my weekly time?
Yeah.
Thank you.
But you're on a short leash because you got the eyes of the court on this now. So,
no, it's great. In
okay.
fact, I had family members in this week when she's making claims. So there was family members in my house. I wasn't playing video games. It's completely gaslighting. So again, thank you for everything. Appreciate it.